Assemblyman Ridley Thomas, if you'd come and present item 22, AB 2005.
And then after that, Senator Wynn.
Thank you, Mr. Vice Chair and colleagues. I join you to present AB 2005, which will reduce the use of inappropriate out-of-state placements in the juvenile justice system. Oh, I'm sorry. You want me to restate?
Sure. You never get too much.
Oh, well. Much too kind of you, Mr. Vice Chair. Mr. Vice Chair and colleagues, it's a pleasure to join you today to present AB 2005, which would reduce the use of inappropriate out-of-state placements in the juvenile justice system. With this bill, it's like 1998 all over again. You remember the Arizona boys camp, a young man who had a California placement. He was in the camp, and he was worked essentially to death. I remember I was in grade school at the time, and it was a major public policy concern, and it was a pattern that we wouldn't have seen had that particular juvenile been in California state custody. So there was a Mike Thompson bill at the SB 933, which was essentially the will of the governor and the legislature to restrict the use of out-of-state placements. But the practice has unfortunately crept back into place, particularly as the group home system, which many of you have scrutinized in various contexts, has not lived up to its highest and best use. So we attempt to look at Welfare Institutions Code 727.1 and go back and look at what the Thompson rules were and strengthen them to make sure that a court gets to evaluate and scrutinize whether or not a juvenile will be placed out of state. We think that it will have the practical impact of making judges aware of these placements. As you know, there are juveniles that are placed outside of the state as far away as the East Coast, and it's very difficult to get them back. Sometimes they're referred to alternative facilities if the institutions in which they were placed are not sufficient for the level of care that the state expects. With that, we have witnesses that can attest to the merits of the proposal and would appreciate your positive consideration, Mr. Vice Chair.
Witnesses in favor?
Yes, good morning. My name is Robin Goldfaden. I'm an attorney with the Youth Law Center. We're honored to be co-sponsoring AB 2005 and are grateful for the opportunity to speak briefly today in support of the bill. AB 2005 addresses a subject that has long been a concern for California, the placement of California's probation-supervised children in out-of-state group homes and similar care facilities. As the report to the committee makes clear, California has adopted numerous measures aimed at limiting the harms of these placements. AB 2005 goes one small but meaningful step forward in strengthening those measures and giving greater effect to them so that we can better ensure that these placements are reserved only for those children for whom it's truly appropriate to their needs and best interests, and that there's been a diligent search that has demonstrated that an adequate in-state alternative is truly not available. Anytime we remove children from the home, there's cause for concern and a need for protection. Those concerns are heightened when children are made a ward of the court and placed in facilities out of state. I won't repeat what has already been said about the dangers that are involved with those, but they also include serious increased risk of long-term harms for the children who do make it back here safely. There's a greater likelihood of reoffending, poorer outcomes. It weakens ties to family and community that are critical for successful reentry and for a path forward with education and jobs. If we're going to permit placements that come with the kinds of risks that out-of-state placements come with, then we ought to be sure that those placements are really necessary and not avoidable. AB 2005 is just going to bring clarity to an area that doesn't have as much clarity as it should. It's not going to add any new substantive or procedural requirements. It's just going to make sure that there is the intended tailoring to each child's best interests and needs as was intended. Thank you.
Good morning, Vice Chair and members. Dennis Cuevas Romero with the Hernandez Strategy Group here on behalf of Communities United for Restorative Youth Justice, one of the co-sponsors of the bill. Courage is the community-based organization that focuses on interrupting the cycle of violence and trying to build community leaders after they've been involved with the criminal justice system. Courage has worked with multiple youth that have been engaged in the criminal justice system and that have unfortunately been placed out of state. Courage has seen multiple adverse consequences to the youth, as has been previously stated. There's data upon data that being close to your support system is essential for the successful reintegration and the future of these youth. For those reasons, we request your aye vote. Thank you.
Any additional witnesses in support?
I'm Kim Lewis, representing Aspira Now, one of the larger foster family agencies in the state, wanting to lend our support to this bill, and we really need to strengthen not only our dependency system, but also our delinquency system too. Thank you.
Craig Brown for the California Correctional Peace Officers Association, in support.
Any witnesses in opposition?
Good morning, Mr. Chair and members. Danielle Sanchez on behalf of the Chief Probation Officers of California, regrettably in opposition today. We certainly share the intent of this bill, and in our conversations with the author's office, we always endeavor to keep these kids locally. There are circumstances where out-of-state placements are sometimes necessary and appropriate. For example, the CSEC population, again, we always try to work with those kids locally, but there are times where in order to get them the specialized services they need, there may not be a placement in California that is either available or appropriate, and I think those two words are very important here. I would say that the continuum of care reform, which the Chief Probation Officers have been very involved with and are continuing to do working groups that will help build capacity in our foster family system and in-group homes, is a great trend toward building up placements in California. But the Chiefs are certainly concerned that we have a bill in front of us that is going to further restrict the ability to use out-of-state placements when necessary without concurrently building up our capacity via this bill to make sure that we have those resources here within California. The result of that, unfortunately, is that this could lead to the unintended consequence of kids staying in our hall longer, which is absolutely not something that the Chief Probation Officers want to see, and we understand from kind of legislative history that the legislature does not want to see either. And so while we appreciate the intent and definitely want to continue the discussion, we're really concerned about this limiting the ability to place kids with the services and programs they need, whether that be in-state or out-of-state, and what that's going to mean for the services that they need. So for those reasons, we ask for your no vote today.
Is there a common ground are there amendments that you think could get you on board with this?
As we currently look at the statute, we believe that there are quite a few statutes already on the books that deal with both the court processes involved in making these determinations as well as the probation's role in making placement determinations. So we don't have specific amendments, but certainly we'll continue that dialogue with the author.
Senators, do you have any questions? Senator Leno.
Thank you. First of all, my appreciation to the author. Been working on similar issues, and I think the steps you're taking are appropriate, but I do want to be sensitive to the Chief Probation Officer's concerns. I have great respect for them, and their intent, I don't believe, is any different than yours. The question is around the operational restrictions that this may place. So my question is, given that, of course, you're not prohibiting anything, you're just putting a few more steps in place, is there, and excuse me, that maybe if I'd read the analysis more thoroughly, I would know, but I'll ask anyway, is there a safety valve in the case where there is, if there is the possibility, there's absolutely no in-state placement, And so according to the bill, the court has to make the specified findings by clear and convincing evidence and to require the court to find that a case plan is already in place and state that the existing authority of the court to place a delinquent ward in juvenile home shall not be construed to authorize a court to commit a minor to one of these facilities
So-
located outside. So what happens when there may not be any other option?
When the initial strictures around this process were enacted in 1998, we had a much larger juvenile population in state
Correct.
custody. And we had more control over how we dealt with that population. As you know, I think that population is at less than 1,000 now, and most of those young people are in probation's hands. Simply by, I think, challenges of the market with respect to group homes and the level of care required if you're going to do it well, and frankly, the business model for group homes are not terribly sustainable. There are, in some instances, counties, even in San Francisco, as I recall, when we started our research on this, where a young person was sent to Pennsylvania to a supposedly appropriate facility, and I think the individual may have had some services that he needed. It was either mental or behavioral health, and he was right around early high school age, like a freshman or eighth grader or ninth grader. And it turns out that the Pennsylvania facility was not the best placement. So he was referred from a Pennsylvania group home, essentially, to a psychiatric hospital in the state of Pennsylvania. His family was unable to reach him, much less oversight. There was a lack of transparency with respect to his level of care. And this was simply becoming a practice for a time in the county of San Francisco because the county couldn't figure out how to find the group homes. There just wasn't enough space. So knowing that there's some young people that will need to be sent out of state, just like our state prison population, we have an adult population at some point out of state. I didn't want to eliminate the option, but I wanted to change the standard to a higher standard, and it's really a signal to the judges to say we need a bit more scrutiny so that there's clear and convincing evidence that it is in the interest of public safety, the benefit for the potential rehabilitation of the juvenile, to place them outside. But if there's any chance, just in case you forgot what happened, this is because the judiciary in some counties hadn't been on the bench. What is that? Is that 18 years ago? Yep. So they may not recall the circumstances, and things have changed. That's why we thought this was a measured attempt. Now, we're happy to work with the chiefs, and LA County has a huge probation population. But, I mean, sometimes we argue in the legislature about being too far away in the same state. But if you're in Nevada or Illinois or Texas or other places, Georgia, they're reducing their prison population significantly, and they want to repurpose these facilities. We don't want to create perverse incentives to sending juveniles out. So that's why we thought that this was a measured approach by simply changing that clear and convincing, which is slightly higher than the threshold right now for scrutinizing the program. But we're happy to, should the bill move forward, to work with your office and the chiefs to more clearly drill down on what our intent is. And I think that there's a happy medium because, as you said, the chiefs don't want to, it's not in their interest because, frankly, if they have successes with this particular potential population, it's a great narrative to say that rehabilitation worked for young people.
And Ms. Sanchez, have you suggested any amendments to the author?
At this time, we're in conversations with that. There's a lot of different layers of code sections that this is changing that are currently on the books, and then, of course, dealing with the court system. So at this time, we have not given specifics, but happy to continue that dialogue, of course.
Okay, sounds good. I'll move the bill.
Thank you, Senator.
Senators, just so that you know, this bill is going to go to the Senate floor. And so the timing of trying to get something worked out, how will that work?
Well, the great thing about the Senate, as I recall, unless the rules have changed since I worked in the Senate, is that you can put amendments across the desk. So we will make a commitment to the committee, if it is the wish of this committee, to have a dialogue, see if there are specific amendments that the chiefs can come with, and we'll keep you in the loop to see if we can reach agreement on a particular standard. We thought that this was sufficiently flexible, but this is an iterative process, and are more than welcome to a more robust dialogue with the chiefs.
Mr. Chair, one last question. On
Senator
your,
Leno, go ahead.
on your point, just looking at the analysis, passed off the floor, your floor, first house, 79-0. Did the chiefs' attention get to this late? How is it we're in the second house, about to get to the second floor, and no amendments have been suggested yet?
No, I appreciate the question. We have been looking into that. We've also been having discussions with Department of Social Services to try to understand what the population numbers look like. We have had conversations with staff, being that we did not weigh in the policy committee in the first house, and that we had more formalized our position after that time. We did not want to weigh in later. We wanted to reserve that, having that dialogue, but then weigh in more formally here in policy committee today.
And we did clean up the bill. Frankly, we started off in a different code section. It was less appropriate. And upon scrutiny of our committees and our own continued due diligence, we found. So to the chief's credit, we changed the code section. We were in a, frankly, non-germane code section when we started. So this is the two or three code sections we're in are more appropriate, frankly.
Okay, thank you.
Any additional questions? We have a motion on the floor. If we could go ahead and take a roll call vote, do pass?
Hancock? Anderson?
No.
Anderson, no. Glazer?
Aye.
Glazer, aye. Leno?
Aye.
Leno, aye. Lou? Lou, aye. Monning? Stone? Stone, aye.
We're going to keep this open so that the chair may add on. And I'm not opposed to voting for this on the floor. I'm hoping that you can come to a resolution. Thank you. Senator Nguyen,
Number one.
would you like to wait or would you like to present?
Wait for the chair.
Okay, I just wanted to check with you. Assemblyman Ting, if you'd come up and present item 29, AB 2607. Please.
Thank you, Senator. Presenting AB 2607. AB 2607 expands current existing law relating to gun violence restraining orders. Currently, a family member or law enforcement official may petition the court to get a gun violence restraining order. In effect, what it does is takes somebody's guns away for 1 year period. It only lasts for 1 year. If it needs to be renewed, they have to go back to the court to petition again. It's modeled after a domestic violence restraining order, so it's a very similar type of process. The process is that the members would go to court, petition, and then that individual, if they've proven to have potentially to be a danger to others or to themselves, could get their guns taken away. We have Ari Freelek from the Law Center to Prevent Gun Violence here to speak in favor.
Witnesses and support, please.
2 years ago, the California legislature enacted AB 1014 to provide Californians with an important tool to reduce the risk of mass shootings and gun violence in our state. As the sponsor said, this law provides legal standing to law enforcement, family, or household members to petition a court to take preventive action when an individual exhibits serious warning signs of violence. Under existing law, this process remains unavailable to other community members who may have unique personal knowledge of a person's mental condition or dangerousness. AB 2607 would help close this gap by allowing treating mental health professionals, educators, and coworkers to also petition a court for issuance of a GVRO. In many cases, these individuals will have more regular contact with their patients, students, or coworkers than family members or law enforcement. They may also be better suited to bring GVRO petitions in circumstances than family members who are estranged from an unstable individual or who may fear the repercussions of filing a petition to disarm a loved one. Although some legislators may very understandably prefer to delay amending new laws, we believe this is a case where a potentially life-saving fix cannot come too soon. A brutally familiar drumbeat of school, workplace, and public shootings have demonstrated the importance of opening our courtroom doors a little wider to allow these individuals to file sworn petitions to prevent violence. To be clear, this legislation would not alter the strict legal standard under which courts must evaluate whether to issue a GVRO. All of the due process protections afforded by existing GVRO statutes would still apply. Ex parte GVROs may only be issued if the judge finds a substantial likelihood that the respondent poses a significant danger to self or others in the near future by having access to a firearm, and that a GVRO is necessary under the circumstances to prevent such harm. GVROs issued after notice and a hearing have to meet an even higher burden of proof to demonstrate, quote, clear and convincing evidence of the respondent's dangerousness and the order's necessity. Existing law also guards against potential abuse of this process by imposing significant criminal penalties on individuals who knowingly file a false or harassing petition, including possible felony perjury charges. Though this bill would expressly not require any person to file these petitions, the legislation would empower well-positioned community members to see something and to say something by filing a sworn petition with a judge when they observe serious threats to the public. We urge you to vote aye.
Thank you. Additional witnesses in support?
Shireen Walter. I'm with the California State PTA, the Parent Teacher Association, and we are in support of this bill.
Thank you. Witnesses in opposition?
Good morning, Micah Doctoroff on behalf of the ACLU of California here in respectful opposition to AB 2607. AB 1014, which created the statutory framework for the existing gun violence restraining order, was enacted in 2014 and just went into effect this past January. When approving that legislation, the legislature very carefully considered the difficult questions now before this committee, balancing the important interests at stake and attempting to create sound policy that both promoted safety and protected civil liberties. We believe that AB 1014, as enacted, properly struck that balance, and without any indication that the law has proved inadequate, we think it premature, just over 6 months into the new law, to change it. While AB 2607 certainly has an important goal, we fear that it creates significant potential for civil rights violations. Under the bill, an employer or coworker could seek an ex parte gun violence restraining order against an employee or coworker. It is not difficult to imagine a situation where a person might harbor irrational suspicions against a coworker based on the coworker's religion, nationality, race, ethnicity, or other identity group that the person dislikes or distrusts. Under the bill, such a person can seek an ex parte order, meaning that a judge will hear a one-sided story and the person subjected to the order will not be informed of the court proceeding and will have no opportunity to contest the allegations. Following the issuance of an order, police could then go to the coworker's house and order the person to surrender their firearms without first notifying the person and approaching the situation in a way that we would expect when police believe a person is armed and dangerous. If the person truthfully said he or she had no firearms, officers might then proceed to search the person's house, all the while the person not having been accused of any wrongdoing. Such confrontations only add to existing distrust between minority communities and law enforcement. Existing law already permits any law enforcement officer to petition the court for either an ex parte order or an emergency order to prohibit a person who they believe owns a gun and poses a significant danger to themselves or others. Under existing law, a coworker, an employer, a mental health worker, or a school employee can go to law enforcement to report their suspicions, and if warranted, law enforcement can then go seek an order. With their background and training in emergency situations and public safety, this is a proper role for law enforcement, and we see no reason to upset the existing process. For these reasons, we respectfully oppose the bill.
Mr. Chairman, members of the committee, Craig DeLuz, representing Gun Owners of California and the California Association of Federal Firearms Licensees, as well as the Firearms Policy Coalition. As was just so eloquently stated, when the law was originally put in place, and started 6 months ago. It was limited to individuals who most likely knew the individual closely, or to those that could be the most objective, and that was law enforcement. By expanding the scope to coworkers, and I'll just give you an example. There are, 2,000 employees that work within the California State Legislature, and that doesn't include anyone who works with the legislature. Any one of them could then be in a position to be able to file a gun violence restraining order against any of you or any of us. And we would not even know that ex parte hearing is taking place. And this is important because we're talking about removing, even if for a temporary period, we're talking about removing a constitutionally enumerated right, even if for a temporary period of time, is unconscionable. So we have issue with the policy in general, but to expand the number of people who have the opportunity to do this is unconscionable. But it's also important to understand, as was pointed out, law enforcement then is given a gun seizure warrant. So they've been given the information that an individual is armed and may harm themselves and is a danger to themselves or others. It creates an opportunity for very bad things and a very bad confrontation to happen. We believe that this is a dangerous thing. We also believe one other thing we wanted to note was, in regards to mental health professionals, I would think that for many who own firearms, it is a very important right to them. And I would think that we would want, if we knew someone owned firearms and they needed some sort of assistance, mental health, that we would want to encourage them to get it, not discourage them by telling them that you may lose your firearms rights if you go and you seek a therapist. This sort of a chilling effect is not the sort of thing that I think we need to be encouraging for anyone, let alone those we know to be armed who may be in need of some mental health assistance. It's for these reasons that we oppose this measure. Thank you.
Thank you. We have had a policy up to now that we have 2 witnesses on either side, so we're now looking for Me Too's for the rest of the witnesses.
We have a slightly different position, Mr. Chair and members, in that we're opposing unless amended. We're not quarreling with the rest of the bill, but the part of the bill that expands the GVRO to mental health workers, which, by the way, is not defined in the bill. I heard somebody say mental health professionals, which is a much smaller category of persons. Therapists have the ability and often the duty under existing law, under the Tarasoff decision, under 5150 of the Welfare and Institutions Code, to take measures when they have a patient that might harm others. This is not a responsibility they take on lightly because it can be very destructive of the therapist-patient relationship. So to allow them to go into court and get an ex parte order against their own patient basically destroys the therapeutic relationship. And I will agree with the previous witness on one point, would have the unintended consequence of deterring people from seeking therapy. Those who need it most may not go because somebody could go and get an ex parte order. That is not what therapists do. They don't go into court to get restraining orders. So for these reasons, we would ask, again, the author to remove therapists from the bill.
Before you step away, when you refer to we, you mean?
California Association of Marriage and Family Therapists. Thank you, Mr. Chair.
Thank you.
Got a little off track there, but representing 32,000 marriage and family therapists in the state.
Thank you.
Amanda Levy on behalf of the California Psychological Association. There are 20,000 psychologists in the state. We are also opposed unless amended for the reasons Mr. Shannon stated.
Thank you.
Chief Ayers representing the California Association for Licensed Professional Clinical Counselors. We are also opposed unless amended.
Thank you.
Roy Griffith on behalf of the California Rifle and Pistol Association and the National Rifle Association, opposed.
James Waters representing 10 hunting and conservation groups in this state and urge you to oppose.
Micah Doctoroff, I have also been asked to voice opposition by the California Public Defenders Association.
Nick Wilcox on behalf of the 27 chapters of the Brady campaign in support. Sorry, I was outside the room talking to a reporter. This is actually a very personal issue to us. Having lost our daughter to a mental patient whom everybody knew was dangerous and was in possession of firearms, we believe that this bill, probably more than any in the last 10 years, could have helped our situation. and we urge your aye vote. And this is a difficult situation. We understand the difficulties with the client-patient privilege and so on, but we believe this bill would help.
We had only had one witness in support, so that's the reason why I didn't hold up on that. I just want to make sure.
Thank you, Senator.
Questions? Senator Leno, your light's on.
Serious issue, I was about to say, not to make light of the seriousness of it, but if I can step outside of it, and given what's just recently occurred, it's not all that easy to do so. It does inspire all sorts of intellectual challenges, and it makes it fascinating from a very detached perspective. But of course, I can't be detached. I may have some incorrect information, Mr. Chair, so if I say anything that needs to be corrected, I would encourage you to allow those who know better to correct me. But,
absolutely.
From our staff work, I believe that, and the ACLU said as much with regard to the Skinner bill, that they were not in opposition. And they were not listed in opposition, nor were the California public defenders on the Skinner bill, though they are both in opposition today. And the argument, if I understood correctly from the ACLU, with regard to family different from co-worker, that I think the suggestion was that family member, of course, knows that family member so much better than a co-worker. I don't know that I necessarily agree with that statement, because we spend more of our waking hours with our co-workers than we do oftentimes with family members. Family members can be estranged or distant. So I'm very solid on the co-worker part as well as the employer part. I do have concerns about the mental health worker, and I understand also that maybe the definition may need to be addressed. I'm also very respectful always of Mr. Wilcox's expertise and experience in this, and I don't know all the details of his situation. And whether that mental health worker was the only person who could have changed the outcome of that. So these are not easy issues, and I also am well aware that Assemblywoman Skinner did take the mental health workers out of her bill. So I just wanted to hear some of your response. Also, getting very specific to that concern, could there be the unintended consequence of someone who is in need of mental health services deciding not to, because out of fear that even if they expressed fantasies of what they've got going on in their heads, that they'd be doing themselves in by pursuing the very help that they need?
Mr. Wilcox, if you'd like to come up to the chair, it may be appropriate at some point for you to respond as well.
Let me just start, and then I'll let Mr. Wilcox and Mr. Freelick also respond as well. The Tarasov decision is very, very narrow, and a mental health worker can only report that individual if they've identified actually a specific individual or something very specific, not if they've talked about violence or even thought about violence, which is really, I think, what we were trying to really stop. I don't necessarily believe that that would hurt the client-patient relationship. Obviously, if someone already is seeking assistance, quite often that's a very positive situation where they've already identified themselves in need. Quite often what we've heard is the individuals who are perpetrating these crimes are actually not seeking help or not even in those situations. So actually being in a therapeutic relationship, I think, would be a very, very positive thing, and I don't think that this would necessarily be a deterrent for that individual.
What would you like me to address, Senator?
Well, I didn't necessarily feel I needed to ask for you to respond. I don't know that the specific situation of your family should necessarily determine what we do with this bill. But of course, I'm always eager to hear from you.
This is a tough call. You guys are in a difficult position. I recognize that. However, I have a friend who is a therapist, and she has said that many times family members are in denial and will not utilize this restraining order where the psychotherapists are fully aware of the potential consequences. And in our particular case, the psychotherapist was fully aware of the danger. He was fully aware that the murderer had a house full of weapons and intended to use them. There were people there at the clinic who were warning, yet there were no tools available.
And current law, even with Skinner in place, would prohibit
the family members would have to bring it forward. And in our particular case,
no, but you said the mental health worker was well aware.
They were well aware, but the way the current law is, the family members have to bring it forward. And in our case, the family members were in denial, and we believe that the brother was the supplier of many of the weapons.
Just to add also, there's no requirement that the mental health worker come forward. It's just an option for them, as it is an option for all the other people in the categories.
I think that's an important point to underscore.
Yeah, there's no requirement.
Right. Thank you.
Are you squared away, or do you have additional questions?
No, I am squared away, Mr. Chair, and
Thank you.
I'm very comfortable moving the bill.
Okay. Senator Stone? did
Thank you,
have a
Mr.
question?
Chairman. I was wondering if we could ask Mr. Shannon to come up and articulate in more detail the concerns of the mental health professionals.
Thank you, Senator Stone. And it is an important point. I want to point out that it is not a requirement, and that is important to understand. But that raises another issue that I didn't get to because I was in the Me Too category, which is there is no protection for liability in this bill in both directions. And when I raise that, I mean, if you do not, you're authorized to use the GVRO. But if you don't, and something bad happens, there will be Monday morning quarterbacking, because lawsuits always happen because something bad happened. So there's no liability protection there. There is also no liability protection if a therapist decides to use this new tool, goes into court, does not get the restraining order, and the patient comes back and says, wait a minute, you went to court, I wasn't there, and my reputation has been sullied, and you've breached the confidential relationship. There is no protection for liability in that instance as well. So those are two important points. Even though it's not required, I just wanted to make those.
Thank you for clarifying that.
Any additional questions? No. Any other members with questions?
Just to ask if we could get the proponent's response to that, to Mr. Shannon's concerns.
Certainly.
I think that's a fair point, and we've previously suggested that amendment, to be frank. I would point out, though, that this is not unique to this context. Mental health professionals would already be exposed to liability for failing or complying with their TerraSoft duties.
Just want to note also on page 3 of the bill, line 6, it says, nothing in this chapter shall be construed to require a person described in paragraph 1 to seek a gun violence restraining order.
And would you like to close?
Again, when we started this bill's journey, it was unfortunately after the San Bernardino case. That San Bernardino case obviously involved a shooting with various coworkers. We saw in previous years the Isla Vista case where you had a student who was away from his family perpetrate really horrendous crimes. And unfortunately, over this last weekend, we had a situation where not only was the shooter identified by law enforcement, identified by his ex-wife, identified by coworkers. Again, we feel that this is a tool that people can use to defend themselves. We all have the right to go to work, to go to school, to frankly be at a nightclub and not be shot and killed. So again, this is just an opportunity for us as normal, ordinary citizens to be able to protect ourselves against gun violence. Respectfully ask for a vote.
Thank you, Senator Leno, for the motion, and this is due pass to appropriations. If we get, Senator Glazer.
Mr. Chair, so I am struggling with this bill. I certainly appreciate the intentions of the author, and I don't know where the committee is in regard to it because I've only heard from one. But I did want to ask whether you had given any consideration to a sunset, if this were to go forward, to putting a sunset on it to have a time in which we could see whether it was working and whether there's unintended consequences. Have you given any thought to that?
We hadn't. It's the first that we proposed to. I think we're always open to changes.
Well, I'm interested in hearing from my colleagues to see where this bill is, but it's causing me some anguish.
I hate to do this to you, but we've had a motion, and I wish you had done that all before. At this point, we're on the cusp of a vote. So I'd like to move forward with a roll call vote. Due pass to approps.
Hancock.
Yes, I've read this bill. I'm sorry, I missed the testimony, but
Hancock, aye. Anderson?
No.
Anderson, no. Glazer? Leno? Leno, aye. Lou? Lou, aye. Monning? Stone?
No.
Stone, no.
call 3 to 2, that bill is on call. Senator Wing is here.